olacak. Şimdi kısaca soruları almak istiyorum. Daha sonra 5 dakika ara verip son oturumumuzu tamamlayacağız.
Teşekkür ederim. Murat Özsunay, İngilizce konuşmamda bir sorun yok herhalde. İki yönde tercüme yapılabiliyor mu?
Nasıl rahat ediyorsanız öyle konuşun.
Daha kolaylık olur diye düşünüyorum. While you're at it, because your slides are still showing up, Murat Özsunay, İstanbul ve Frankfurt baroları, aynı zamanda da zaman zaman ICC hakemliği yapıyorum. I was wondering if maybe if you could go back, or maybe you don't need to go back in your slides, but if you could clarify the relationship in between the AAA rules, which are institutional rules, and the federal code, which I'm sure, so to say, has some mandatory provisions as well. So to make a comparison, you could say that the federal rules are probably like your Windows system, your operating system, and that your AAA is your Microsoft Windows, so to say. Are there any mandatory rules, which I assume are in the federal rules? And if there are, could you mention a few of those which need to be observed? And the other thing I was curious about was, to my surprise, because although I was educated partially also in the U.S., I don't have U.S. arbitration practice. The law, applicable law, can be, of course, chosen by the parties, and I'm assuming in domestic arbitration, it's mostly the U.S. law or the law of a certain state. But you said the arbitrators are not really bound by not only procedural law, but also by substantive law. Now, does the arbitration clause does it have to be specified in the arbitration clause that the arbitrators have a right to ignore, so to say, the substantive rules of law and do it their way based on tradition or commercial practices and so? And my final question is, how about setting aside of judgments, of arbitral awards? You said unless the parties ask for it, the award does not need to have a reasoning. Now, if there's no reasoning in the award, what are your criteria for setting aside an award? Thank you very much.
Okay,
Teşekkürler.
those are all excellent questions. Let me try to address the first and third question together, because I think there is a relationship there. And then the second question with respect to the law separately. First of all, you had asked, are there any mandatory provisions in the Federal Arbitration Act? And these are actually the slides that I tried to go through very quickly, so I guess I will have an opportunity to go into a little bit more information. Some of the mandatory requirements under the FAA are with respect to, first of all, staying a litigation if there's an arbitration clause, and I talked about that a little bit. There are also the requirements that if an award is rendered, the court must enforce the award. And I mean, it's shall, must, very concrete language. So that's intended to make sure that courts are not trying to reevaluate what the arbitrators did in substance. The courts are supposed to focus more on, was there anything improper about the award? And this is your third question. If you do not have a reasoned award, you basically have a one sentence that says party A is awarded $500,000 in this dispute. and that's all you have, how do you then go about showing that the award should be overturned? And one of the prongs on which an award can be overturned is arbitrator misconduct. So, for example, you may have to submit affidavits, written statements to the court saying, on behalf of Party A, we attempted to introduce these 3 key items of evidence, and the arbitrators dismissed our request, and instead of saying that they thought the information was not relevant to the dispute, they said, it's been a long day. I don't want to listen to this. I mean, it's an extreme example, but you would introduce evidence of what the arbitrators did or did not do. So, there are grounds on which you can challenge the arbitrator's conduct. Another ground on which to challenge the award that I had on one of the slides that I mentioned briefly is if the arbitrators go beyond their powers. And what that basically means is that if the contract basically says, no attorney's fees or costs shall be awarded by the arbitrators, and the arbitrators decide that they thought that the conduct of one of the parties was really egregious and they think costs are warranted and they award costs, you then have a basis for saying they exceeded their powers under the contract. So those are all examples where, even if you don't have a reasoned award, you can challenge the process. But the whole intent is to make sure that it is a limited review process so that you are not going through the time and expense of the appeals process in court. Does that answer those questions? Okay. All right. Then let me move on to the question with respect to, rule of law and what the arbitrators need to consider. You had posed the question of, does it need to be specified in the arbitration clause that they are to disregard the strict interpretation of the law? In some industries, it does not need to be specified. I keep using insurance as an example, and that's because that is the majority of the arbitration work that I do. But it certainly helps if you have that language in your clause, because, again, the parties provide specific powers to the arbitrators, and the arbitrators' powers are derived from what's in the written arbitration clause. So if that written arbitration clause specifically has the language from the examples that I put up on the slides that says you may look to custom and practice, you don't need to strictly apply the law, then certainly your argument is made stronger. And if, for example, you were to try to challenge an arbitration award perhaps on the basis that the arbitrators exceeded their powers, maybe you could assert this is what the contract said, that's not what the arbitrators did. Anything more on that question? Because I'm trying to remember all of them. Okay, thank you.
Teşekkürler. Arkada
Ben stajyer avukat Sinem Şahin. I also have a question for Ms. Stevens. Do you mind briefly mentioning the baseball arbitration and if AAA runs it, or if in the multinational arbitration do we see such kind of arbitration, a baseball arbitration?
Yes, baseball arbitration is actually a very interesting concept, and I'm not sure I've heard all of your question, but let me try to give an example of a baseball arbitration, and then you can let me know if I need to elaborate further. Baseball arbitration typically involves a situation where the parties agree that they will submit a particular dollar value for their case to the arbitrator, and the arbitrator can then either toss that like a ball if he doesn't like it, or accept it. And it's kind of a unique approach to arbitration because some parties view it as much more risky, because instead of trying to see what value the arbitrator will arrive at him or herself, there's already a specific figure that's being proposed. Do you want me to elaborate on that?
I was wondering if it's often for international arbitration.
I have had only one example of a baseball arbitration, and it was actually in the international context. It was a reinsurance arbitration involving a reinsurance company based in Europe and an insurer based in the United States. In that particular proceeding, I can't go into the details because of confidentiality reasons. We did represent the reinsurer, and the idea was that we felt that we had a strong case and we could proceed on that basis. And fortunately for our client, we were successful, but that's the only example that I have. So I can't comment on how broadly it's used in other industries.
Another type of arbitration, specific arbitration that is frequently used where I come from, is high-low arbitration, where the parties agree that the award will not exceed a certain amount or be beneath a certain amount, but they don't tell the arbitrator that. We call it blind high-low arbitration. It's used frequently in personal injury cases, medical malpractice cases, and the like, so that the claimant is guaranteed a minimum amount, but the defendant or the responding party does not have to worry about going beyond a certain amount. So the award can be between the two extremes, but cannot exceed them.
Teşekkürler. Başka sorusu olan var mıydı? O zaman kısa bir ara veriyoruz. Sonra kısaltılmış bir şekilde bir saat gibi son oturumumuzu yapıp kapatıp hep birlikte bir boğaz turu yapacağız. Çok teşekkürler. Görüşmek üzere.